Hello, Defense Attorney Mark Rosenfeld here. I wanted to talk about preliminary hearings for a couple of minutes. Preliminary hearings are a special hearing in front of a judge, not in front of a jury, but in front of a judge, where a judge decides whether or not there is enough evidence to go forward with a case towards trial. Now, a preliminary hearing is only on felonies, not in misdemeanors, and you have a right to a preliminary hearing within 10 days. This is very important on felonies because many times a person is in custody, they're in jail, waiting for their preliminary hearing or their trial, and it's important to move quickly within those 10 days. Now, there are some exceptions where it may be able to go past the 10 days, but that's typically rare unless the person waives or gives up their right to a speedy preliminary hearing, and they may choose to do that after consulting with their attorney. If the person is out of custody, they're not in jail, then it is fairly common to waive the speedy preliminary hearing rights and go beyond the 10 days. But if the person is in custody, we usually want to move pretty quickly. Now, another part of a preliminary hearing is the fact that we can use a preliminary hearing to get information about the case. Now, it's not designed for discovery where you're like taking depositions or exchanging information, but many times working with the district attorney's office, we are able to use the preliminary hearing process to get information on the case. Police reports, supplemental police reports, video, and then ultimately at the hearing, if we're going forward with the preliminary hearing, there will be evidence presented and we can use that as an opportunity to learn more about the case. So the discovery or exchange of information can be an important part of a preliminary hearing. Now, preliminary hearings are, as I mentioned, in front of a judge, not in front of a jury, and many times there are limited witnesses. There's a Prop 115 which allows the prosecution to go forward in most preliminary hearings with a specially trained or experienced police officer, where the police officer can report back information that was gathered during the investigation and streamline the process. So many times we're not going to have all of the witnesses that we would like at a preliminary hearing. It may just be one police officer who is testifying, and we're forced to work with that. Now, because of this streamlined process and the burden that the prosecution must meet, many times people are held to answer, or the preliminary hearing is against the defendant. So when someone is stopped and arrested, the officers have to have reasonable suspicion to make the stop and probable cause to make the arrest. The preliminary hearing is that same probable cause standard. Is there enough information where a judge can say, yes, I believe that there is probable cause that this crime occurred, therefore I'm going to allow it to proceed to trial, or at least in that direction. So the standard of proof is relatively low at a preliminary hearing, so many times people are held to answer. It's against the defendant, and the defense would lose the preliminary hearing and the person would be going forward towards trial. Now, this doesn't mean that we don't do preliminary hearings, and it doesn't mean that we can't use the preliminary hearings for these other issues like discovery, getting information. We can also use the preliminary hearing to try to settle or resolve the case. There may be witnesses there, police officer, other witnesses that may be able to give the district attorney who's working on it more information, and the district attorney's office may have more time before a preliminary hearing to review and discuss with the defense attorney what the best possible outcomes would be for the case. So many cases would settle through a negotiation plea bargain before the preliminary hearing, or sometimes after the preliminary hearing, but on that same day. So it's important to know that another benefit of moving forward towards a preliminary hearing is the opportunity to get a district attorney to really look at the case, understand what the issues are, and maybe be able to settle or resolve the case. Another thing that can happen at a preliminary hearing is if you are held to answer, if a person is held to answer, where evidence is presented and a judge believes that yes, there is enough evidence to go forward on this charge, but it might not be on all charges. So a judge may hold a person to answer on certain charges in a preliminary hearing and find that there is insufficient evidence on others, or a judge may reduce a charge on their own motion from a felony to a misdemeanor, which a lot of times will help resolve a case. So there's a lot of moving parts in a preliminary hearing. Sometimes it can move very quickly within 10 days. Sometimes it takes much longer. I've had preliminary hearings that don't take place for 6-9 months, maybe a little bit more than that, depending on the particular facts of the case. Every case is different. The court system does like to move them along pretty quickly, but if there are extenuating circumstances, preliminary hearings can be trailed or extended out. If you've got questions about preliminary hearings or other criminal matters, feel free to give me a call. I handle cases in Southern California. My office is in Beverly Hills, and you can reach me directly at 310-424-3145, 310-424-3145. Be safe.